Hello everyone, good morning. Recently, the Supreme Court of India has formed a three-judge constitutional bench in order to decide the issue regarding Article 375, Section 375 of IPC, which deals with rape. Right? In Section 375 of IPC, there are two exemptions. One exemption is the rape which is committed by a husband on his wife is not considered as a crime. So this was the question. Now why this is in news is recently there are two high courts in India. One is from Karnataka, the second one is from Delhi. Karnataka High Court said that marital rape is a criminal offense, whereas Delhi High Court said we cannot take a call whether that amounts to criminal offense or not. In this context, let's look at what exactly is the question in news and how the Supreme Court Constitutional Bench is going to look at this. So Supreme Court, this is the news. Supreme Court agrees to list the pleas to criminalize marital rape before three-judge bench. So it was kept before a three-judge bench. That bench is going to decide whether the rape which was committed by a husband on her wife amounts to rape or not. That is the thing. Now let's look at what exactly is rape. Rape is made as a criminal offense in IPC, Chapter 16 of IPC, Section 375 deals with rape, Section 376 deals with the punishment for rape. So this is Section 375 of IPC, Indian Penal Code. So what exactly it says? A man is said to commit rape, right, under ABCD. All these are speaking about sexual intercourse. If we have a sexual intercourse, a man is said to have sexual intercourse with a woman under the following circumstances: against the will of the woman, against the consent of the woman, or if the consent is obtained by coercion, or if the consent is obtained when because she believes that he is a man. So this is coercion. The next one is, this is coercion. The eighth one is by cheating, or with her consent when the time of such consent by reason of unsoundness or mind, by some intoxication, if he is committing sexual intercourse, again that is a crime. Sixth one is with or without her consent if she is under 18 years of age. Very important. If she is 18 years of age or below 18 years of age, then that girl is said to be a minor. Hence, having sexual intercourse with a minor is an offense under Article 375 when she is unable to communicate her consent. So this is called rape. So having sexual intercourse with a woman against her will, against her consent. Consent is obtained by coercion, consent is obtained by cheating, consent is obtained by something like when the woman was unable to communicate her consent, or if it is a minor girl. So who is a minor? She is less than 18 years. So this is a minor. However, there are two exemptions for this. One exemption is if it is for medical procedure, if this intrusions has happened because of medical procedures, then you cannot consider it as a rape. That is completely fine. But section 2 is something which is in dilemma. Exception 2 says sexual intercourse or sexual acts by a man with his own wife cannot be considered as a rape. This is the thing. And the wife's age earlier was under 15 years, but this was changed to 18 years. It should be noted that the girl is considered as a minor if she is less than 18 years. This is as per 2013 Criminal Law Amendment, right? So this is also known as Nirbhaya Act. In the year 2013, government has amended the criminal laws, and then it has made Nirbhaya Act, under which the age of a girl has increased to 18 years. After this, she is said to be a major. Otherwise, she is a minor. Committing rape on a minor or having sexual intercourse with a minor is a rape. So this is the thing. Now, what exactly is the problem under this sections of IPC is, this is the section. The second exemption under Article 375 is at discussion now. What exactly it says? A sexual intercourse of a man with his own wife cannot be considered as a rape. Now the question is whether this can be considered as a rape or not, right? Because if the sexual intercourse is against the will of her husband or of her wife, of his wife, then definitely that has to be committed as a rape. In this context, what Karnataka government recently, Karnataka court has said, High Court of Karnataka said, a man is a man, an act is an act, a rape is a rape, be it performed by the man, whether that man may be the husband or the wife. So the Karnataka High Court has observed in its decision saying an accused should be brought to the justice regardless of the immunity in the penal code. So how can IPC give immunity to the husbands if they are committing rape against their wife? So this is what Karnataka High Court has said. However, the problem has come with the Delhi High Court, where there was a split verdict in the Delhi High Court saying that we cannot decide exactly that it is a rape or not, because it has to be decided by the law, and law is to be decided by the legislature. However, there is one precedent for this. In 2013, Justice J.S. Verma committee was tasked in order to revive or in order to relook into the crimes against women and the laws which are related to crimes against women in IPC. So what this Verma committee said this, the exemption 2 under Article 370, Section 375 has to be removed. So J.S. Verma committee recommended that you have to remove the exception for marital rape and proposed that the law should specify that marital and other relationships between the perpetrator and the victim is not valid defense against the crimes of rape or sexual violation. So what J.S. Verma committee recommended is the law should be made, and it has to be made in such a way that this exemption is removed. This is what the recommendation is. So Delhi High Court said that it has to be decided by the law, whereas Karnataka High Court said that it can be considered as a criminal offense. Now the people went to the petitions went to the Supreme Court. As a result, Supreme Court has formed a 3 judgments to decide whether 375 section of IPC exemption 2 is really valid or not. We have to wait and watch what exactly is going to happen. So this is what you mean about Article 375. So what are the important things? So in which section of IPC discusses with this? Section 375 of IPC discusses with rape. So there are 2 exemptions for this. One exemption is medical examination. Second one is marital rape. Justice J.S. Verma committee said that you have to remove this. Karnataka High Court also said to remove this, but High Court of Delhi said that it is legislative body which has to remove it. Now Supreme Court has formed 3 judgments to decide whether Section 375 exemption 2 is valid or not. This is what the news is. So this will be a day-to-day current affairs. Please follow it. Just check what exactly is this, then you'll understand these things. So thanks for joining. Have a great day.